Okay, okay. Good afternoon, everyone. We can start the session. So we'll start with CPC. We are to start with marathon of CPC. So today we'll be covering up from section 1 to 28 and order 1 to 22. So we'll try to be as quick as possible, and we will try to cover all the aspects and elements of this portion of CPC. Now, first divide. Divide this. Let's divide this session into certain provisions. As in, what provisions are we going to take up? So let us divide this provision. Just give me a second. Visible? Is this visible? Everyone? Is this visible? Okay. Okay. I guess this is visible. So let us start with the session. So we will be starting with 1 to 78 of CPC. So now let's understand what all are the elements provided in 1 to 78. So now let's first, what all things we will study in this session, what all things we will understand in this session. Let us understand those things. So now, see, with respect to this session, first thing that we will understand is basically the concept of jurisdiction, and all the jurisdictions in CPC. So first we will understand concept of jurisdiction and all the jurisdictions within CPC. So here we will start with section 9, and then we will understand the concept of first pecuniary jurisdiction, what exactly is a pecuniary jurisdiction, and then we will understand the concept of uh, territorial jurisdiction, and then we will understand the concept of subject matter jurisdiction. Okay, and then we will understand the concept of subject matter jurisdiction. So from section 9, we will move on to various sections which deal with jurisdiction. So for example, pecuniary jurisdiction is dealt by three sections, that is section 3, and you have section 6 also, and you have section 15 also. These are the three sections that deal with the concept of pecuniary jurisdiction, and then territorial jurisdiction is dealt by section 16 to 20. Section 16 to 20 is dealt by territorial jurisdiction, the concept of territorial jurisdiction. Now, interestingly, subject matter jurisdiction is not dealt anywhere. Subject matter jurisdiction is one such jurisdiction which is not dealt anywhere, but it is implicit in section 9. It is something that is implicit in section 9. Now, once we are done with this, then we will go on to the concept of res judicata, and thereafterwards we will understand the concept of res sub judice. What exactly is res sub judice? And then ultimately, we will understand the concept of foreign judgments, broad concept of foreign judgment, and what exactly term foreign judgment means, and how foreign judgment can be executed, and how foreign judgment is relevant in India. All these aspects we will cover. Now, once we are done with this, then we will move on to the other ancillary topics. So the first target is these topics. First target is these topics, and within this, here we will cover something known as transfer of cases. Right after jurisdiction, we will cover something known as transfer of cases. Now, transfer of cases ranges from section 22 to 25. Okay, 22 to 25. So we will understand what exactly transfer of cases exactly means, and what is the concept behind transfer of cases. Fine. Are you guys clear with the agenda for first half? Are you guys clear with the agenda of the first half? Wait a second. Okay, the agenda of first half is clear, everyone? Okay. Okay, let's start. Just give me a second now. Wait, there is. Uh, just give me a second. Just give me a second. Okay. Okay, let's start with the session. So first is overview. Okay, overview of CPC. CPC and its overview. So see, firstly, why it is why civil procedure code is called a code. You guys know what is the difference between code and act. See, code is a compilation of all the existing laws. So CPC, the word code is a compilation of all the acts. So CPC, the word code is a compilation of all the acts that are provided. So it is basically a compilation of all the acts that were prior to coming of CPC that were existing. So the word code means compilation. So CPC is basically a compilation of all the acts that were actually there, which were existent prior to CPC. So it compiles all the acts which actually provided for civil procedure, and it brings us one CPC. On the other hand, act का मतलब ये होता है कि when the legislature has created something new out of their own wisdom, that is act. But CPC is a code. So basically what is happening, all the civil procedures that were prior to CPC, that are coming together and we are forming one particular code. Now what is the purpose of CPC? The broad purpose of CPC is to consolidate all the laws relating to civil procedure and to amend also the laws to civil procedure. And that is the reason we can say that it compiles all the pre-existing acts. So all the pre-existing acts that were existent prior to CPC. So CPC just compiles all of them and brings them all together. So for example, 1859 Act of CPC, civil procedure, was existent prior to this code. 1877 and 1882. So CPC is compiling all of them and coming into and bringing them together as 1908 Act. पहला तो ये समझना है. अब ये प्रोसीजरल लॉ है एंड आपको पता है why it is a procedural law, because it dictates procedure. How are we supposed to seek remedies, uh, and this is not a substantive law, and since it is a procedural law, it gives effect to the principle of ubi jus ibi remedium. So CPC provides complete and effectiveness to this maxim. So wherever there is a right, there is a remedy. So how are we supposed to obtain these remedies? So CPC provides for an effective mechanism to obtain these remedies. Now it is, you can say that it is complementary to substantive law. Now why it is complementary to substantive law? Because whenever there is substantive law, CPC has to be invoked to seek enforcement of that substantive law. Now, these are the few traits of CPC: that it is a procedural law, it gives effect to the maximum of ubi jus ibi remedium, and it is complementary to substantive law. And CPC cannot go against the Constitution; it cannot rise above the Constitution. So, it has to adhere to certain principles in the Constitution. One is principles of justice, equity, and good conscience; principles of reasonableness; principles of non-arbitrariness; principles of fairness. All these aspects CPC has to adhere to. And then uh, CPC has private and public purpose both. So CPC aims at resolving a dispute between, so the see, first purpose is that it aims to resolve dispute between two parties. So this is a private purpose. दो पार्टीज के बीच में डिस्प्यूट रिजॉल्व करने का मकसद है सीपीसी का. सो दिस इज बेसिकली अ प्राइवेट पर्पस कि दो पार्टी में हार्मनी क्रिएट कर रहे हो. बट इसका पब्लिक पर्पस भी है. सीपीसी हैज अ लार्जर पब्लिक पर्पस. फर्स्ट, इट ब्रिंग्स सर्टेनिटी इन लीगल रिलेशंस, it resolves dispute between individuals and society, and it brings greater stability. तो ये उसका public purpose है. So this you can say that it is a private purpose, and here you can say that it has a larger public purpose as well. Fine. Now CPC does balancing of rights. So whenever any person's right has been encroached, so we balance both the rights, and then we come into the actual then we come into the actual result. So CPC balances the interest of both the parties. Who is to lose more if such an event happens? So that is what CPC asks. This is the question that CPC asks. Now, rules of interpretation. What rules of interpretation will you follow in CPC? So simple. First, you will follow literal rule. When there is no ambiguity, you will follow literal interpretation. जब कोई एम्बिग्विटी नहीं है तो आप सिर्फ लिटरल इंटरप्रिटेशन फॉलो करोगे. So when there is no ambiguity, but if there is ambiguity, in that case you will follow something known as purposive interpretation. Purposive interpretation का मतलब है you will actually examine the purpose of CPC and in line of the purpose you will actually interpret a particular provision. So this is what purposive interpretation means. Fine. तो ये है आपका purposive interpretation. Now अब डायरेक्टली आ जाते हैं हम द प्रोसीजर, ब्रॉड प्रोसीजर ऑफ सीपीसी. नाउ दिस इज वेरी इंपॉर्टेंट फॉर यू टू अंडरस्टैंड, क्योंकि इससे ही सारे आपके एस्पेक्ट्स क्लियर होंगे एंड जो फर्दर टॉपिक्स हैं वो सारे क्लियर होंगे. एंड दिस यू गाइज हैव टू बी थरो अबाउट. एक सेकेंड, आर यू क्लियर टिल हियर? यहाँ तक क्लियर है? टिल यू गया क्लियर? टिल यू गया क्लियर? यहाँ तक क्लियर हो? यहाँ तक क्लियर है ना? Okay, just give me a second. I'll just turn on this from my, so that I can see your comments. I will just attach one more device. Comments visible नहीं होते. Wait a second. Vikas, can you send me the link on WhatsApp once more? Sir, can you clear interpretation part? Yeah, I'll clear the interpretation part. Just give me a second. Vikas, can you send me? एक second. Okay, sir. Okay. So let's start. Now it's best. ठीक है. Is it visible, guys? Visible है ना? Visible, everyone? जल्दी टाइप करो. Visible? Okay. So let's start with it. Okay. So see, now let's understand the procedure behind CPC. पूरा procedure पहले समझो. पहला है, हम जब भी start करते हैं, first we file a plaint in duplicate. So this is the first thing that we do. We file a plaint in duplicate, and this plaint is filed in filing counter, and this plaint is filed under order 4 rule 1. Order 4 rule 1 में this plaint is filed. Then after that what happens? There is the numbering of suit takes place. So what will happen? So after you have filed the plaint in duplicate, then ultimately what will happen? There will be numbering of suits. So what happens in numbering of suit? The reader examines the valuation and he will raise certain office objections. So reader will raise certain office objections, and only after clearing those office objections, only after the office objections are cleared, the suit will be registered. So reader will raise office objections, and only after office objections are cleared, only after office objections are cleared, only after OOs are cleared, office objections are cleared, the suit will be said to be registered. So these objections can be relating to valuation. These objections can be relating to the structure of the structure of the plaint. These objections can be as to any technicalities relating to the plaint. उसके बाद ऑफिस ऑब्जेक्शन रेज करेगा. अब आइडली प्लेंटिफ को 7 दिन के अंदर अंदर ये ऑफिस ऑब्जेक्शंस करेक्ट करने हैं. Now, if within 7 days the plaintiff does not correct these objections, then the plaint will either be rejected or the plaint will be accepted. ठीक है. अगर मान लो कि सारे नेसेसरी ऑफिस ऑब्जेक्शंस आर करेक्टेड विद इन 7 days, देन द प्लेंट इज अल्टीमेटली एक्सेप्टेड. सो प्लेंट को आप एक्सेप्ट कर दोगे. ठीक है. अब प्लेंट एक्सेप्ट करने के बाद क्या होगा? द मोमेंट प्लेंट इज एक्सेप्टेड तो समन्स इशू करने का ऑर्डर पास होगा. दिस इज एन ऑर्डर पास्ड अंडर ऑर्डर 5 रूल 9. So that is known as the order of issue of summons. Now once issue of summon का ऑर्डर पास हो गया, then it is a duty upon the plaintiff. प्लेंटिफ के ऊपर एक ड्यूटी है कि प्लेंटिफ हैज टू पे समथिंग नोन एज अ प्रोसेस फी. प्लेंटिफ हैज टू पे समथिंग नोन एज प्रोसेस फी, एंड दिस प्रोसेस फी हैज टू बी पेड विद इन 7 days. सो प्लेंटिफ को प्रोसेस फी बोल सकते हैं, प्रोसेस फी पे करनी है, और प्रोसेस फी ये 7 दिन के अंदर पे करनी है. एंड दिस इज समथिंग विच हैज बीन प्रोवाइडेड इन ऑर्डर 7 रूल 9. अब व्हाट आर द कॉन्सिक्वेंसेज ऑफ नॉट पेइंग दिस प्रोसेस फी? अगर प्लेंटिफ मान लो प्रोसेस फी नहीं पे करता, यहाँ पर ऑर्डर पास हुआ समन्स का, समन कोर्ट ने बोला कि समन इशू करते हैं, और यहाँ पर प्लेंटिफ को प्रोसेस फी पे करनी है. मान लो प्रोसेस फी प्लेंटिफ नहीं पे करता, सो इन दैट केस वन थिंग कैन हैपन. पहला है द प्लेंट कैन बी रिजेक्टेड. दूसरा है द सूट कैन ऑल्सो बी डिसमिस्ड. सो प्लेंट कैन बी रिजेक्टेड and the suit can also be dismissed. Suit can also be dismissed. Now these are the two consequences of not paying the process fee. Now once the process fee is paid, मान लो process fee अब pay हो गई, then the court will serve the summons upon the defendant. अब जैसे ही summons process fee pay कर दी plaintiff ने, तो defendant के ऊपर summons serve करेगा. अब after the summon is served upon the defendant will naturally appear. Now once he appear, then he will have to file written statement, and this written statement will be filed within 30 days. 30 दिन के अंदर अंदर ये written statement फाइल करना चाहिए, and this period can extend to 90 days. ये period 90 days के लिए extend हो सकता है. ठीक है. This period can be extended up to 90 days. Now, the question that arises is, if the defendant wants to file WS after 90 days, अगर 90 days के बाद फाइल करना जाता है WS, will that be allowed? What do you guys think? Will that be allowed? क्या वो allowed किया जाएगा? Guys, ideally WS has to be filed within 30 days. It can be extended up to 90 days. If after 90 days the defendant wants to file a WS, will that be allowed? क्या लगता है बाकी लोग? Yes. Risar says yes. Yes, if sufficient cause is shown. Yes, but under what provision? What will be the provision for allowing that WS? Under what provision? See, that is something that is allowed, but that is allowed under Order 8, Rule 10. And it is allowed in exceptional cases when you can show specific cause. So in exceptional cases it is allowed, and when you can show sufficient cause, and it is more than sufficient cause. Okay. Now after this, after WS is filed, then there will be something known as first hearing. फिर आती है first hearing आपकी. First hearing में court pleadings examine करेगा, pleadings देखेगा, WS और plaintiff दोनों, plaintiff और defendant के, वो देख लेगा. उसके बाद court admissions और denials लेगा. Court will take into account admissions and denials, and ultimately the court will examine parties. And after examination of parties, the court will see whether it is a fit case for alternate dispute resolution, whether it is a fit case for, say, arbitration, whether it is a fit case for, say, conciliation, whether it is a fit case for, say, judicial settlement, whether it is a fit case for say judicial settlement, and say whether it is a fit case for whether it is a fit case for say lok adalat, to send the matter to lok adalat, and whether it is a fit case for say mediation. कोर्ट ये सारी चीजें एग्जामिन करेगा, एंड इफ द कोर्ट फील्स दैट इट इज अ फिट केस फॉर एनी ऑफ दीज एडीआरस, देन द कोर्ट विल ट्रांसफर द केस टू एडीआर. ठीक है, एडीआर के लिए भेज देगा. बट द कोर्ट फील्स दैट दिस इज नॉट अ फिट केस फॉर एडीआर. मान लो कोर्ट को लगता है कि ये फिट केस नहीं है एडीआर के लिए, और इफ द एडीआर, कोर्ट ने एडीआर भेजा था बट एडीआर हैज फेल्ड, so in such cases what will happen? In such cases then you will settle the issues, you will go for settlement of issues. Now whenever issues are settled only on those points, this is something that has been provided in order 14, and issues are settled only on those points where parties are at variance. अगर parties variance पे है, only on those points the issues will be settled. After settlement of issues there will be trial. ट्रायल में क्या होगा, आप एविडेंसेस लोगे दोनों साइड से, and ultimately you will come up with a judgment. And judgment is something that has been defined in 2.9 and order 20 में उसका procedural aspect है. After that what will happen? After judgment has pronounced, that won't be the end of CPC. उसके बाद आता है execution, that is another Herculean task. So उसके बाद आता है execution, फिर आप execution के लिए जाओगे, and after execution there will be now if there is execution then there can be appeal also, appeal भी हो सकती है, and अगर order reverse हो गया appeal में, and then there can be something known as restitution as well. Now this is the broad procedure of CPC. ये broad procedure है CPC में, इसमें बहुत सारे technicalities हैं, but अब हमें एक एक करके सारी चीजें समझनी है. Now first, तो सूट कैसे इंस्टीट्यूट होता है? तो ये तो आपको पता है कि इट इज टू बी इंस्टीट्यूटेड बाय समथिंग नोन एज अ प्लेंट. प्लेंट से इंस्टीट्यूट होता है, which is filed by the plaintiff, and why it is filed, why is this plaint filed by the plaintiff, that also you have to understand. So it is filed in order to obtain the relief that is claimed by the plaintiff. Now what is the difference between a suit and a plaint? See, plaint is the proceedings, suit is the proceedings and plaint is the document that is filed for pleading. So suit is set of proceedings and plaint is document of pleading. Every proceeding started from numbering of the suit until the final judgment will be the part of suit. So every proceeding starting from numbering. So every proceeding starting from numbering until final judgment is a part of, will be a part of suit. So will be a part of suit. ठीक है, तो ये है आपका सूट एंड प्लेंट. अब सेक्शन 26 talks about the same. 26 says that every suit shall be instituted by presenting a plaint. So every suit has to be instituted by presenting a plaint. You cannot institute suit any other manner. So it can be instituted by presenting the plaint or in such other manner. Now such other manner का मतलब है कि it can be instituted by a suit can be initiated by petition. जैसे हिंदू मैरिज एक्ट में हम petition फाइल करते हैं, जैसे इंडियन सक्सेशन एक्ट में we file an application, but generally a suit has to be instituted. A suit is started with a plaint. In certain cases it can be in certain cases it can be filed by using applications or petitions. Now this is something which section 26 provides, and one other thing that section 26 provides, that whenever a plaint is filed, all the facts that are provided in the plaint have to be proved by affidavit. अब इसका कारण क्यों? Why affidavit? जब एक verification clause है तो affidavit क्यों? When there is a verification clause, then why affidavit? So उसका कारण ये है क्योंकि affidavit gives rise to something known as, it creates a criminal liability, and a person who lies on affidavit will be held liable for. बताइए, a person who lies on affidavit, कोई भी affidavit में झूठ बोलता है, what will be he held liable for? Correct. he'll be held liable for perjury. So basically that is the reason we have provided that it has to be proved by affidavit. So इसके लिए हर plaint को it has to be, facts shall be proved by affidavit. Now this is section 26 के start कैसे होता है. How does the thing start? How does the suit start? Starts by filing a plaint. Up, then you have order 4. Order 4 provides for a comprehensive procedure. Of order 4 clarity बोलता है कि यार देखो हर suit में you will have to file duplicate plaints, and every plaint will comply with the rules of order 6 and 7. So rules of order 6 and 7. So order 6 क्या है guys? Order 6 क्या है? Rules of pleading. And order 7, what exactly is order 7? Rules of plaint. Correct. So basically every plaint shall comply with rules contained in order 6 and 7. तो पहले तो plaint duplicate में होने चाहिए, दूसरा है order 6 और 7 में comply होनी चाहिए. अगर ये दोनों हैं, then only the plaint will be deemed to be duly instituted, otherwise it will not be duly instituted. And if the plaint is not duly instituted, तो हम क्या करेंगे? Then we will raise office objection. Office objections will be raised by the court. And these office objections, once they are raised, corrections have to be made within 7 days. If the corrections are not made within 7 days, then ultimately the plaint will be rejected. That is what the broad principle is. अब ये 7 days का जो period मैंने आपको यहाँ बताया, ये कहीं पर भी CPC में provided नहीं है. It is a matter of custom in many courts that this objection has to be cleared within 7 days. But many courts provide for a much larger procedure, much larger time as well. So they provide for a greater time as well. So as a hard and fast rule nahi hai. Then you have section 9. Section 9 provides for gateway of CPC. What exactly? Section 9 provides for gateway of CPC. So basically you can say that the entry to CPC is through section 9. The basis of CPC is section 9, because section 9 says that the court shall have jurisdiction. The courts shall have jurisdiction to try all suits of civil nature, excepting the cognizance of which their cognizance is either expressly or impliedly barred. So this is basically, you can say that this is the gateway of CPC. This is giving immense jurisdiction to civil courts. You are giving that civil courts have jurisdiction to try all suits of civil nature, except 2 suits, except which are barred within CPC, and which are barred outside CPC, which are barred within CPC and which are barred outside CPC, barred within CPC or barred outside CPC. So courts shall have jurisdiction to try all suits of civil nature, except the suits of which cognizance is either expressly or impliedly barred. So basically bar within CPC or bar outside CPC. Now one thing that you have to understand here. Now what is the restriction here? Now see, there are 2 restrictions that are provided. So basically civil courts have broad powers, but they are restricted in 2 means. एक है bar within CPC. They are restricted by bar within CPC, and they are also restricted by bar outside CPC. So वैसे तो civil courts के पास broad powers है, but they are restricted within CPC. If there is any other provision within CPC which prohibits or bars them, then they are restricted. If there is any other provisions outside CPC which stops them or restricts them, then also they are restricted. So these are the only 2 aspects which restrict them, that is bar within CPC and bar outside CPC. अब इसके बाद what is the purpose of section 9? तो इसमें purpose में इतना detail में जाने की जरूरत नहीं, बस one thing that you have to understand that section 9 says that every court needs to have inherent jurisdiction. क्योंकि कोर्ट के पास inherent jurisdiction है, so individual also has an inherent right to get a suit tried by the civil court, and the above right is obviously subject to bars within CPC and also restrictions outside CPC. तो 3 चीजें बोल रहे हैं. कि पहले तो कोर्ट के पास इनहेरेंट जुरिस्डिक्शन है, अब क्योंकि कोर्ट के पास इनहेरेंट जुरिस्डिक्शन है तो इंडिविजुअल के पास इनहेरेंट राइट है। अब इंडिविजुअल के पास इनहेरेंट राइट है, इसका ये मतलब नहीं कि ये राइट एब्सोल्यूट है, इसके पास रिस्ट्रिक्शंस है। रिस्ट्रिक्शन सीपीसी के अंदर भी प्रोवाइडेड है और सीपीसी के बाहर भी प्रोवाइडेड है, एंड दैट इज व्हाट that is what was held in Abdul Ghaffur versus State of Uttarakhand. उसके बाद इन गंगाबाई वर्सेस विजय कुमार एंड आरसीआरटी वर्सेस बाल मुकुंद बैरवा, basically section 9 was defined was explained in detail, and it was connected to ubi jazibi remedium, maximum of ubi jazibi remedium, that section 9 gives effect to the maximum of ubi jazibi remedium. And one other important thing that was held in this case was that there will be presumption of jurisdiction. Whenever a suit is filed, the court will start with a presumption that it has jurisdiction, and the burden will lie upon the opposite party to deny it. जब भी सूट फाइल होगा तो कोर्ट हमेशा एक प्रिजम्पशन से स्टार्ट करेगा कि यार उसके पास जुरिस्डिक्शन है, और बर्डन डिफेंडेंट के ऊपर लाई करेगा ये प्रूव करने का कि उसके पास जुरिस्डिक्शन नहीं है. बट व्हाट इफ द डिफेक्ट ऑफ जुरिस्डिक्शन इज मैनिफेस्ट? ऑन फेस पे ही आप बोल सकते हो कि देयर इज अ डिफेक्ट ऑफ जुरिस्डिक्शन, देन द कोर्ट विल जस्ट रिटर्न द प्लेट. अब ये सारे सिनेरियोज हैं. And then there is this concept of suit of civil nature. They have used the word suit of civil nature. They haven't used the word civil only. Why they have used the word civil nature? This you have to understand. So जब civil nature का जो मतलब है, it is wider than legal rights. So civil nature का मतलब है not only legal rights, but along with legal rights, other socio-economic rights also. So other socio-economic rights are also included. So not only legal rights, but also socio-economic rights are also included in the word civil nature. But one thing that you have to be careful about this: the legal rights have to be dominant. Legal rights have to be dominant and integral part. And if the case involves only socio-economic rights, if the case only involves socio-economic rights, if the case only involves socio-economic rights, then it is not a suit of civil nature. Then not a suit of civil nature. उस केस में आप नहीं बोल सकते. It will not be considered to be a suit of civil nature in such a case. ठीक है? Clear you guys? Clear? Clear you guys? Clear? Guys, clear you guys? Clear? आगे बढ़ा जाए. ठीक है. अब आगे ये है कि मान लो A is a person, he was discarded from his caste. अब therefore he filed a suit to be reinstated in caste. उसको डिस्कार्ड कर दिया था कास्ट से, तो उसने सूट फाइल किया कि मुझे कास्ट में वापस लो. अब लॉ इज नॉट इंटरेस्टेड इन सच अ केस बिकॉज दिस इज अ प्योर सोशल इशू. बट यहीं पर ही इफ had he been denied food, reputation and shelter due to expulsion from caste, so he could have filed the suit because this is not a pure social issue. Along with social issue, there are some legal rights also involved. So social issue के साथ कुछ legal rights भी involved. So right to food, shelter, reputation plus inclusion of caste. So there is basically one is a socio-economic, one is legal right. पहला legal right है. And second is a socio-economic question. ठीक है? That ultimately gives rise to a suit of civil nature. That ultimately gives rise to a suit of that ultimately gives rise to suit of civil nature. ठीक है? तो ये हो जाएगा ultimately suit of civil nature. Fine. Now, suit of civil nature was defined in this case. Most Reverend PMA Metropolitan Moran Marthoma. The word civil was defined in this case, and it was defined that what word civil was defined and why they have used the word not only civil, but they have used the word civil nature. So nature का मतलब है fundamental qualities of a person or a thing. So they want this word civil nature to be broader than just civil. So civil means legal right. when they have used the word civil nature, they want it to be more broader than legal right. So not only disputes involving legal rights, but also dispute concerned with socio-economic rights of an individual. But one thing that we have to keep in mind, that in all these disputes, legal rights have to be the most essential and dominant part. So say if legal right is not the essential and dominant part, मान लो लीगल राइट सबसे एसेंशियल और डोमिनेंट पार्ट नहीं है इन दैट केस, देन इट विल नॉट बी अ सूट ऑफ सिविल नेचर. तो ये एक बेसिक चीज है कि सिविल राइट लीगल राइट प्लस सोशो इकोनॉमिक राइट But one thing that you have to keep in mind, that legal right plus socio-economic right is equals to civil nature, but this legal right has to be the essential and dominant part. ये जो legal right है, it has to be the most essential and dominant part. Fine. तो ये हो गया most reverend versus metropolitan. These are the few examples of suits which are of suits of civil nature. जैसे suit for carrying out a religious procession, suit for right for worship, right to dower, right to collect areas of rent, right to divorce, uh, right of a pardanashin woman to observe parda. If husband marries another woman and wife claims injunction, that will also be a suit of civil nature, because husband is under an obligation not to marry a second wife. Right of adult franchise, all these are suits of civil nature. Ab second term that you have to understand that is used in section 9 is express and implied bar. So express and implied bar का यही मतलब है कि when there is a special law created for special subject matter and it has expressly barred the jurisdiction of civil courts, then you can say it is an express bar. अगर एक special law create किया है special subject matter में and it has specifically barred the jurisdiction of civil court, then in that case you can say express bar. It is an express bar. But now there is a special law created and a special court is also created, but jurisdiction of this court is not barred. Jurisdiction of this court or civil court is not barred. In that case, you will examine the purpose of that law. You will examine the express provisions of that law. You will examine the terms of reference of that court. And then you will understand whether there is then you will examine whether the intention of legislature was to bar the jurisdiction of civil court. इसको हम बोलते हैं implied bar. Implied bar का मतलब है कि लॉ में एक्सप्रेसली तो प्रोवाइडेड नहीं है कि द jurisdiction of civil court is barred, but from the purpose of the law, from the various provisions of the law, from the terms of reference of that code, and we can understand that the intention of the legislature was such that they wanted to bar the jurisdiction of the civil courts. That is something known as implied bar. ठीक है, यहाँ तक क्लियर हो? Clear you get clear? Clear you get clear? Clear you get clear? ठीक है, आगे बढ़े. ठीक है, अब आते हैं jurisdiction पे. Now what exactly jurisdiction is? See, jurisdiction, three types of jurisdictions are there. One is a territorial jurisdiction, second is pecuniary jurisdiction, and the third is subject matter jurisdiction. अब देखो territorial jurisdiction जो है, territorial jurisdiction is a jurisdiction that is actually defined, or it ranges from section 16 to 20. So territorial jurisdiction का जो broad concept है, it is something which has been provided in section 16 to 20. And then you have pecuniary jurisdiction. अब आपका जो pecuniary jurisdiction है, pecuniary jurisdiction is something that has been provided in section 3. It is also been provided in section 6. And it is also been provided in section 15. On conjoint reading of these three sections, we can come to the concept of pecuniary jurisdiction. Subject matter jurisdiction is not provided anywhere, but we can infer it. We can infer it from section. Section 9, because they use the word express or implied bar. So एक्सप्रेस और इम्प्लाइड बार का यही मतलब है कि देयर इज सम सब्जेक्ट मैटर jurisdiction that has been created, and that subject matter jurisdiction, if that subject matter jurisdiction is created, then in that case the court of the jurisdiction of civil court is barred. So this is something known as subject matter jurisdiction. अब इतना समझ लो कि मान लो किसी कोर्ट के पास टेरिटोरियल jurisdiction नहीं है और पिक्यूनरी jurisdiction भी नहीं है और वो डिक्री पास करती है, then that decree will be illegal and irregular. तो अगर कोर्ट के पास टेरिटोरियल jurisdiction नहीं है, कोर्ट के पास पिक्यूनरी jurisdiction नहीं है, and the court a decree is passed, that decree is illegal and irregular. So मान लो no territorial, no pecuniary, no territorial, no pecuniary. Fine. Then in that case, the decree that is passed, decree passed is illegal or irregular. Decree that is passed is illegal or irregular. Fine. अब आते हैं सब्जेक्ट मैटर jurisdiction पे. सब्जेक्ट मैटर jurisdiction को आप समझते हैं. Till here you guys are clear? यहाँ तक क्लियर हो? ठीक. और उसी केस में मान लो कोर्ट के पास सब्जेक्ट मैटर jurisdiction नहीं है. मान लो कोर्ट के पास there is no subject matter jurisdiction of with the court and the court still goes on and passes on the decree. So in such cases the decree will be void. उस केस में void decree होगी. ठीक है. तो basically if there is no territorial, no pecuniary jurisdiction and the court still goes and passes on the decree, then the decree will be illegal or irregular. But if there is no subject matter jurisdiction, then the decree will be void. तो अगर टेरिटोरियल और पिक्यूनरी jurisdiction नहीं है और कोर्ट फिर भी डिक्री पास करने के लिए जाता है, देन द डिक्री विल बी इलीगल और इरेगुलर. बट अगर सब्जेक्ट मैटर jurisdiction ही नहीं है, देन द डिक्री विल बी अ वॉइड डिक्री. फाइन. अब पहले आते हैं, समझते हैं पिक्यूनरी jurisdiction. अब पिक्यूनरी jurisdiction को समझने के लिए यू हैव टू अंडरस्टैंड द कॉन्सेप्ट ऑफ सबऑर्डिनेशन ऑफ कोर्ट्स. तो वो दैट इज समथिंग व्हिच हैज बीन प्रोवाइडेड इन सेक्शन 3. तो सबऑर्डिनेशन ऑफ कोर्ट्स क्या है कि कोर्ट्स की हायरार्की क्या है. तो दिस इज हाउ द कोर्ट्स हायरार्की इज. टॉप मोस्ट यू हैव हाई कोर्ट, देन यू हैव डिस्ट्रिक्ट कोर्ट, देन यू हैव सिविल जज सीनियर डिवीजन, देन यू हैव सिविल जज जूनियर डिवीजन एंड देन स्मॉल कॉजेस कोर्ट. और ये आपका सारा सेक्शन 3 में प्रोवाइडेड है कि फॉर द पर्पस ऑफ दिस कोर्ट, डिस्ट्रिक्ट कोर्ट इज सबऑर्डिनेट टू हाई कोर्ट and every civil court of a grade inferior to district court, and every court of small causes is subordinate to high court and district court. So this is how the hierarchy is: high court, district court, then the courts inferior to district court, that is civil judge senior division and civil judge junior division, and ultimately small causes court. So ये section 3 provides for subordination of court. इसको हम बोलते हैं subordination of court. ठीक है. अब सबऑर्डिनेशन के बाद सेक्शन 6. अब सेक्शन 6 क्या बताता है कि हर कोर्ट के पास एक पिक्यूनरी वैल्यू jurisdiction है. There is a pecuniary jurisdiction with every court. So every court has a jurisdiction, a pecuniary jurisdiction over the amount or value of the subject matter. And whenever this exceeds, whenever the dispute exceeds the pecuniary jurisdiction, whenever आप pecuniary limit से exceed कर देते हो, ordinary pecuniary limit से, then the suit, basically suit cannot be instituted in such a court. So you cannot exceed that pecuniary limit. हर कोर्ट के पास एक pecuniary limit है और आप उससे बढ़ नहीं सकते. अब this is ये तो छोड़ो पहले. अब दिल्ली में this is the pecuniary jurisdiction in Delhi. दिल्ली में ये pecuniary jurisdiction है. आपके judges of small causes till 5,000, senior civil judge or CJ 5,000 to 3 lakhs, district judge 3 lakhs to 2 crores, and about 2 crores you have, about 2 CR you will go to high court. Now this is the pecuniary jurisdiction in Delhi. One thing that you have to understand, that every suit has to be instituted in the court of lowest grade. So even if the superior court has jurisdiction, but if lower and superior court both have jurisdiction, मान लो कि civil judge district court के पास भी jurisdiction है और civil judge के पास भी jurisdiction है, तो उस केस में किसके पास जाओगे? Where will you file the suit? सूट कहाँ पर डालोगे? अगर डिस्ट्रिक्ट कोर्ट के पास भी jurisdiction है और सिविल जज के पास भी jurisdiction है, where will you file the suit? Definitely सिविल जज, डेफिनेटली सिविल जज के पास जाओगे. ठीक है. नाउ दिस इज व्हाट योर पिक्यूनरी जुरिस्डिक्शन मींस. सो ये 3 सेक्शंस में ही पिक्यूनरी जुरिस्डिक्शन समझ जाता है. पहला है सबऑर्डिनेशन, सेक्शन 3, एंड देन यू हैव सेक्शन 3 यू हैव सबऑर्डिनेशन. सेक्शन 3 सबऑर्डिनेशन है. सेक्शन 6 बताओ क्या है. 6 क्या है. सेक्शन 3 सबऑर्डिनेशन, सेक्शन 6 क्या है. पिक्यूनरी ना, पिक्यूनरी जुरिस्डिक्शन. सेक्शन 6 इज पिक्यूनरी जुरिस्डिक्शन, पिक्यूनरी जुरिस्डिक्शन. करेक्ट. अब सेक्शन 15 क्या बोलता है. सेक्शन 15 टेल्स यू दैट इट हैज टू बी बिफोर द लोएस्ट कोर्ट. लोएस्ट कोर्ट में आपका सूट होना चाहिए. अब ये हो गया पिक्यूनरी जुरिस्डिक्शन. नाउ कम टू सब्जेक्ट टेरिटोरियल जुरिस्डिक्शन. सी टेरिटोरियल जुरिस्डिक्शन का हिसाब बहुत ही सिंपल है. सी टेरिटोरियल जुरिस्डिक्शन में फर्स्टली यू हैव टू अंडरस्टैंड वन थिंग कि इफ द मैटर इज रेसिडुअरी, say ideally if the matter falls under 16 to 19, these are the specific provisions. If the matter falls under 16 to 19, then it will be dealt accordingly. But if the matter does not fall under 16 to 19, then the matter is residuary, and in such cases section 20 will kick in. So पहले तो first we will examine whether the matter falls under 16 to 19. यदि मैटर 16 टू 19 में नहीं फॉल करता तो फिर हम रेसिड्यूरी प्रोविजन पे जाते हैं. पहले तो 16 टू 19 समझो. 16 टू 19 इज बेसिकली सूट इन्वॉल्विंग इमूवेबल प्रॉपर्टी. सो व्हेनेवर द सूट इज इन्वॉल्विंग इमूवेबल प्रॉपर्टी, सो वेयर विल यू फाइल द सूट. सो आइडियली द सूट हैज टू बी फाइल्ड वेयर द इमूवेबल प्रॉपर्टी इज सिचुएटेड. ठीक है. देन यू हैव सेक्शन 17 and 18. What if one immovable property is situated within the jurisdiction of 2 courts? Then obviously you can file it within the jurisdiction of any court. दोनों में से कोई भी कोर्ट में फाइल कर लो. मान लो एक इमूवेबल प्रॉपर्टी 2 कोर्ट की जुरिस्डिक्शन में सिचुएटेड है, तो सूट कहाँ फाइल कर सकते हो. दोनों कोर्ट्स में फाइल कर सकते हो. What if jurisdiction is uncertain? So if jurisdiction is uncertain, then also you can file it in that court where after making a record of uncertainty. ठीक है. अब अगर केस इन सब में नहीं है, then section 20 will kick in. तो पहले तो section 20 है क्या. So section 20 provides that a suit has to be instituted, a suit has to be filed where defendant actually or voluntarily resides, carries on the business or personally works for it. या cause of action wholly or in part arises. So section 20 says that suit has to be filed in the place where the defendant actually and voluntarily reside, A, B, or defendant carries on the business, C, personally works for B. ठीक है. यहाँ cause of action जहाँ पर arise हो रहा है wholly or partly. So 2 things. First is defendant, wherever defendant actually and voluntarily resides, carries on the business, personally works for gain. Second, cause of action, wherever cause of action wholly or partly arises. So वहाँ पर आप वो territory में you will file the suit. This is what section 20 tries to say. Now the main question arises, what if there are more than one defendant? What if there are more than one defendant? And for that, this provision has added each of the defendants, and clause B has added any of the defendants. So now if there are more than one defendant, in that case you will see whether all the defendant can be found at one place. क्या सारे ही defendant एक ही जगह पे मिल सकते हैं? If all of them can be found at one place, then you can file the suit at the place of work of those defendant, or at the place of business or place of residence. So basically, if all the defendants can be found at one place, then you can file the suit then you can file the suit there itself. That won't be a problem. But if there is a common if there is a common place for all the defendants, then you can file the suit there itself. But what if all the defendants cannot be found at a common place? मान लो एक डिफेंडेंट रह रहा है एक जगह पर और बाकी दूसरी जगह पर रह रहे हैं. They cannot be found at the common place. So in such cases, you will require leave of the defendant, or you will require acquaintances of all the defendant who are not resident. तो जब मैं बोलता हूँ कि all the defendants are found at common place, तो समझ लो जैसे ये तीन है, P है, एक S है और H है. All of them are found at Mumbai. या तो कोई काम कर रहा है मुंबई में, कोई रह रहा है, कोई बिजनेस कर रहा है. So some or the other how they are found in Mumbai, there is a common place. Now since there is a common place, so no leave of court is required, no acquaintance is required. कुछ भी जरूरत नहीं है. You can just directly, the plaintiff can just directly institute a suit in Mumbai. But अब अगर यहीं पर ही मैं बोलूं कि एक बंदा मुंबई में काम कर रहा है, एक डिफेंडेंट पटना में रह रहा है और दूसरा बिजनेस कर रहा है रायगढ़ में. अब नाउ देयर इज नो कॉमन प्लेस. तीनों अलग अलग जगह पे रह रहे हैं और काम कर रहे हैं, तीनों अलग अलग जगह पे हैं. सो इफ आई वांट टू इंस्टीट्यूट अ सूट इन मुंबई से, so I will either require the permission of the court, I will either require the leave of the court, or I will require the acquiescence, consent of all the defendant who are not residing in Mumbai. तो जो भी मुंबई में नहीं रह रहे, जैसे शिवसंग एंड हसन आर नॉट रिसाइडिंग इन मुंबई, so in such cases I will require permission of these people. So this is what happens when there are more than one defendant. So when there are more than one defendant, if all the defendants are found in a common place, then in that case no leave of the court is required, no acquaintances of all the defendant who are not resident is required. But if any of the defendant is residing in one place, or he is found in one place and the other are not found in that place, in such cases you will either require the leave of the court or permission of the defendants who are not residing. So both can happen. So this is what section 20 subsection 1 provides and section 20 subsection 2 provides. Is this clear, guys? Is this clear? Is this clear? Is this clear? Everyone, is this clear? Okay. Now see, one thing that you have to understand, why section stresses on the word where defendant can be found. See, because what equity requires is that equity and justice requires the plaintiff to follow the defendant to the place wherever the defendant may be found. So it requires the plaintiff to follow at the place wherever the defendant will be found, because that will be the place where you can actually file the suit. So जब भी आपको सूट फाइल करना है तो आपको उस जगह पे जाना पड़ेगा जहाँ पर डिफेंडेंट है. So you cannot just stay in your place and file a suit. So जब भी आप सूट फाइल करोगे उसी जगह पर जाके फाइल करोगे जहाँ पर डिफेंडेंट रिसाइड करता है. So therefore you can file the suit at the place of work of the defendant, at the place of business of the defendant, or the place of residence of the defendant. ठीक है. अब सेक्शन 20 एक और चीज इनेबल करता है. It also enables you to file the suit wherever cause of action has partly or wholly arisen. अब ये मैंने आपको एक एग्जांपल दिया था, ये एक एग्जांपल है. एंड बेसिकली देयर इज अ कॉन्ट्रैक्ट बिटवीन ए एंड बी के बीच में कॉन्ट्रैक्ट है. बी वो कॉन्ट्रैक्ट ब्रीच करता है. अब जो ए है, ए इज अ रेसिडेंट ऑफ नैनीताल, ही वर्क्स फॉर गेन इन दिल्ली. बी इज अ रेसिडेंट ऑफ नैनीताल, he works for gain in Delhi, and he has a business in Mumbai, and the contract was entered in Bangalore. Now आप कहाँ बोलोगे, कहाँ, and it was supposed to be performed in Chennai. Now कौन सी कोर्ट में सूट फाइल कर सकते हो? So I told you that you can file the suit in all courts. You can file the suit in Nainital also, you can file the suit in Delhi also, you can file the suit in Mumbai also, Bangalore also. हर जगह पर cause of action arise हुआ है. Not only cause of action, there are some places wherein the person resides, तो defendant actually resides, तो नैनीताल में जैसे he works for gain, नैनीताल में he resides, दिल्ली में he works for gain, बिजनेस है मुंबई में, तो ये सारी तो चीजें 21 में ही आ गई, ये 20 क्लॉज 1 में ही आ गई। अब फिर बैंगलोर चेन्नई वाली जो बात है कि कॉन्ट्रैक्ट बैंगलोर में हुआ और चेन्नई में परफॉर्म होना था, ये तो कॉज ऑफ एक्शन से रिलेटेड बात हो गई, तो दीज थिंग्स फॉल अंडर कॉज ऑफ एक्शन। तो ऑल दीज आर नोन एज प्लेसेस ऑफ जुरिडिकल चॉइसेस, मतलब यहाँ पर हमारे हमारे प्लेटिव के पास चॉइस है वेर एवर ही वांट्स टू फाइल अ सूट, सो ही हैज अ चॉइस वेर एवर ही वांट्स टू फाइल अ सूट। ठीक है, अब देन कम्स द मोस्ट इंपॉर्टेंट थिंग, एक्सप्लेनेशन। अब एक्सप्लेनेशन टू सेक्शन 20 प्रोवाइड्स कि भाई प्लेस ऑफ बिजनेस इंसान के लिए तो ठीक है, वेर एवर ही इज कैरिंग ऑन द बिजनेस, वेर एवर ह्यूमन के लिए तो वी कैन से दैट वेर ही इज कैरिंग ऑन अ बिजनेस, बट व्हाट अबाउट कॉर्पोरेशन? Where can the corporation be said to be where can the corporation be said to carry on a business? So a corporation can be said to carry on the business where it has its sole office. So जहाँ पर भी corporation की sole office है, sole और principal office है, so wherever the corporation has sole or principal office, so wherever the corporation has sole or principal office, that place, so wherever the corporation has sole or principal office, that place you can say that corporation can carry on the business in India, or if the corporation has branch office, मान लो branch office है, then in that case if the cause of action has arisen there, that will be the place of business. So अगर कोई कंपनी है, अगर कंपनी के पास एक ही ऑफिस है, द सोल ऑफिस, सो अगर एक ही ऑफिस है, दैट सोल ऑफिस विल बी द प्लेस ऑफ बिजनेस। बट अगर कंपनी के पास प्रिंसिपल ऑफिस है और ब्रांचेस भी हैं, ब्रांच ऑफिसेज भी हैं, देन इन दैट केस आल्सो प्रिंसिपल ऑफिस विल सेट टू हैव बी द प्लेस ऑफ बिजनेस। पर अगर कंपनी के पास प्रिंसिपल ऑफिस भी है, ब्रांच ऑफिस भी है, और कॉज ऑफ एक्शन ब्रांच ऑफिस में अराइज हो रहा है, अब उस केस में प्लेस ऑफ बिजनेस कौन सा होगा? विल इट बी प्रिंसिपल ऑफिस और ब्रांच ऑफिस? व्हाट डू यू गाइस थिंक? उस केस में क्या होगा प्लेस ऑफ बिजनेस? विल इट बी प्रिंसिपल ऑफिस और ब्रांच ऑफिस? देखो, एक कंपनी है, अगर एक कंपनी के पास एक ही ऑफिस है, देन प्लेस ऑफ बिजनेस विल बी द सोल ऑफिस। सोल ऑफिस विल बी कंसिडर्ड टू बी प्लेस ऑफ बिजनेस। ठीक है, कंपनी के पास मान लो एक प्रिंसिपल ऑफिस है, and along with principal office the company has a branch office. Fine, उस केस में the branch office will be considered, in such a case the branch office will be considered to be the place of business. If the company has a principal office plus branch office, ठीक है, if the company has a principal office or a branch office, if the company has a principal office plus branch office, then in that case, and plus cause of action, principal office भी है, branch office भी है, and then you have cause of action. ठीक है, if the company has a principal office and a branch office, and then there is a cause of action is at branch office. Cause of action is at branch office. ठीक है, in such cases you can say, अगर cause of action branch office में है, so in such cases you can if the cause of action is at branch office, in such cases you can say that company carries on the business at branch office. branch office पे ही company business carry कर रही है. This is what the explanation is trying to say. ठीक है, यहाँ तक clear हो? And this interpretation was provided in Patel Roadways versus Prasad Trading Company. अगर आपको याद होगा कि जहाँ पर कंपनी के पास सोल ऑफिस है तो प्लेस ऑफ बिजनेस भी सोल ऑफिस हो जाएगी, कंपनी के पास हेड ऑफिस भी है और ब्रांच ऑफिस भी है, प्लेस ऑफ बिजनेस विल बी द हेड ऑफिस अगेन, company has a head office and a branch office, and a cause of action is arising at the branch office, then the place of business will be branch office. This is something which was held in Prasad Patel Roadways versus Prasad Trading Company, and it was also held in New Mumbai Transport versus United India Insurance. Now then there is one thing, that is exclusive jurisdiction clause. मान लो दो competent कोर्ट हैं और आप, if there are two competent courts and you are entering into you are entering into an agreement with the other party to exclude the jurisdiction of one particular court, then in that case will such a clause be void? अगर आप एग्रीमेंट में लिख रहे हो कि सब्जेक्ट टू सो jurisdiction of so and so court only, so there are two competent courts and you are excluding the jurisdiction of one particular court, then in that case will the contract be, will such a contract fall under the ambit of 28, and will that contract be void? The answer is no. If you are excluding the jurisdiction of one of the court, then the contract will not be void. ठीक है? But if you are conferring the jurisdiction of the court which does not have, अगर आप ऐसी कोर्ट को jurisdiction दे रहे हो जिसके पास jurisdiction नहीं है, then in that case basically you are violating section 28 of Indian Contract Act, and that is void. So basically if you are conferring jurisdiction, on court which does not have sorry, if you are conferring jurisdiction on court which does not have, then basically the contract is void, clause is void. If you are not, if there are two courts which have jurisdiction, दो कोर्ट्स के पास jurisdiction है और आप एक कोर्ट को वो कर रहे हो, you are basically excluding one court, ठीक है? Two courts have jurisdiction and you are excluding one court by entering into an agreement. Now this is not void. Basically it was held in ABC Lemonade Private Limited versus AP Agency, that when one of the two competent courts are excluded by agreement, it does not amount to absolute restraint. That won't be an absolute restraint, and it does not fall under section 28 of Indian Contract Act. But a contract to confer jurisdiction upon the court which does not have, that will be void. So parties cannot by mutual agreement confer upon the court which does not have jurisdiction, that will be void, violative of section 23 and 28. ठीक है? अब आ जाओ एक इंटरेस्टिंग सिनेरियो पे कि एक सेकेंड, ठीक है, ये सेक्शन 16 है, हाँ सेक्शन 16 पे ना अभी, क्लियर यू guys are clear? यहाँ तक क्लियर हो? क्लियर यू guys are clear? Guys, clear you guys are clear? ठीक है, आगे बढ़े. Should we proceed further? Yes. ठीक है, एक सेकेंड बस. ठीक है, रुकिए. इमूवेबल प्रॉपर्टी से वी विल स्टार्ट. इमूवेबल प्रॉपर्टी में देखो, इमूवेबल प्रॉपर्टी में एक चीज हम समझेंगे कि whenever a suit is filed and the suit relates to immovable property, then in such cases the suit will be filed where the immovable property is actually situated. तो सूट वहां पर फाइल होगा जहां पर immovable property actually situated है. ठीक है, तो मान लो suit is for recovery of immovable property, then the suit will be filed where the immovable property is actually situated. Suit partition है immovable property का, suit will be filed where the immovable property is actually situated. Suit is for foreclosure, sale or redemption of a mortgage of or charge upon the immovable property. Again, suit will be filed where immovable property is situated. Suit is for determination of any other right relating to immovable property. Suit will be filed where immovable property is situated. Suit is for compensation of wrong for immovable property. Suit again will be filed where immovable property is situated. If it is for recovery of movable property actually under distraint and attachment, again the suit will be filed where immovable property is situated. So in all these clauses, the suit will be filed in the place where immovable property is actually situated. ठीक है, जहां पर immovable property actually situated है वहां पर suit will be filed. And then you have a beautiful proviso. Proviso आपको एक interesting scenario के बारे में बात करता है. Proviso बोलता है कि मान लो the suit is for relief respecting immovable property. मान लो सूट इमूवेबल प्रॉपर्टी से ही रिलेटेड है, बट इट कैन बी एग्जीक्यूटेड थ्रू पर्सनल ओबीडियंस. है इमूवेबल प्रॉपर्टी से रिलेटेड, बट सिर्फ पर्सनल ओबीडियंस के द्वारा ही उसको हम एग्जीक्यूट कर सकते हैं. सो इन सच केसेस द सूट विल नॉट ओनली बी फाइल्ड suit can not only be filed at the place where property is situated, but suit can also be filed at the place where defendant carries on the business, personally works for gain, and then you have the third element, carries on the business, personally works for gain, and voluntary resides. ठीक है, तो ये तीन जगहों पर एक्चुअली एंड वॉलंटरी रिसाइड्स, ये तीन जगहों पर ऑल्सो यू कैन फाइल अ सूट. सो दिस इज समथिंग नोन एज द कॉन्सेप्ट ऑफ पर्सनल ओबीडियंस. कि बेसिकली these are the cases wherein the property, the suit will be filed not only where the property is situated. ये वो केसेस हैं जहां पर सूट फाइल उसी जगह पर नहीं होगा जहां पर प्रॉपर्टी सिचुएटेड है, but it will also be filed where the defendant actually and voluntarily resides, personally works for gain, and carries on the business. तो ये तो सूट्स प्रॉपर्टी से रिलेटेड हैं, but they can be executed only by holding the defendant liable. So either by arresting the defendant or by attaching his other property. Only through these means you can actually execute these suits. So that is the reason we call these suits of personal obedience. इसके लिए हम इनको पर्सनल ओबीडियंस के सूट्स कॉल करते हैं, and that is the reason they can be executed, they can be filed, these suits can be filed not only where the property is situated, but also where the defendant is actually voluntarily residing, where the defendant is carrying on the business, and where the defendant is working. तो उन जगहों पर भी हो सकता है. तो एग्जाम्पल इसका सिंपल है कि मान लो कि देयर इज एच एंड डब्ल्यू है. एच एंड डब्ल्यू हैव अ जॉइंट प्रॉपर्टी, हस्बैंड और वाइफ है, दोनों की एक जॉइंट प्रॉपर्टी है, दे हैव अ जॉइंट प्रॉपर्टी. ठीक है, अब दे इंटर इनटू अ कॉन्फ्लिक्ट एंड डब्ल्यू स्टार्ट्स टू रिसाइड इन पुणे. अब जो प्रॉपर्टी है, दैट प्रॉपर्टी इज से इन गुरुग्राम. फाइन, H is also residing in Gurugram. अब W is in Pune. Fine. अब क्या होता है, H falls in love with W1 and he wants to gift this property to W1. अब H wants to file a suit to stop the transfer of this gift. अब this is a matter involving relating to immovable property. घर गिफ्ट कर रहा है ना, so this is a matter involving immovable property. बट अब इसका एग्जीक्यूशन कैसे करोगे? क्या एच को हम इमूवेबल प्रॉपर्टी के ऊपर कुछ करके रोकेंगे? नहीं. वी कैन स्टॉप एच बाय एक्चुअली अरेस्टिंग हिम और अटैचिंग हिज अदर प्रॉपर्टी. ठीक है, तो वैसे ही हम रोक सकते हैं. सो दिस इज अ केस ऑफ पर्सनल ओबीडियंस. सो इन सच केसेस, सपोज प्रॉपर्टी गुरुग्राम में है, मान लो प्रॉपर्टी गुरुग्राम में है, एच भी गुरुग्राम में रह रहा है, एंड प्रॉपर्टी जो ट्रांसफर हुई है, property is in Gurugram and H is also residing in Gurugram, but he works in Delhi, and he carries on a business in Noida. Now where all can this W file a suit? W कहाँ suit file कर सकती है? Tell me, where all W can file a suit? बोलिए, where all W can file a suit? Where all W can file a suit? कहाँ कहाँ W फाइल सूट कर सकती है? In all three places. Correct. In all three places. In all four, in all three places. Gurugram is twice. Correct. In all three places. Now this is what is provided in section 16. अब दूसरा है determination of any other right in immovable property. So 16(1)(d) इसको बोलते हैं. This is a residuary right. This is residuary. So here we are talking about all the rights that are all the residuary rights in immovable property. So if there are other residuary rights in immovable property, those rights will also fall under the dynamics. If there are other residuary rights in immovable property, those rights will also fall under 16. Those rights will also fall under these dynamics. ठीक है. So उस rights के लिए भी आपको उस rights के लिए भी you will have to file the suit where the property is situated. This is what personal obedience means. So when the decree can be executed by making judgment debtor personally liable. So only in cases where the decree can be executed by making judgment debtor personally liable, then only you can say that the case is of personal obedience. Otherwise, it is not a personal obedience. So basically, by arresting him or attaching him, so you can say that this is a case of personal obedience. And this is what proviso provides for. अब एक इंटरेस्टिंग केस है. अब इंटरेस्टिंग केस क्या ही है, ये आप सबको ही पता है. हर्षद चिमनलाल मोदी वर्सेस डीएलएफ यूनिवर्सल. तो इसमें ए और बी दे एंटर इनटू अ कॉन्ट्रैक्ट इन दिल्ली. दोनों भी दिल्ली में कॉन्ट्रैक्ट के एंटर हुए. एंड दे एंटर इनटू अ कॉन्ट्रैक्ट इन दिल्ली फॉर कंस्ट्रक्शन ऑफ हाउस. एंड दिस वाज द फॉर कंस्ट्रक्शन ऑफ हाउस इन गुड़गांव. दे एंटर इनटू अ कॉन्ट्रैक्ट इन दिल्ली. घर था गुड़गांव में और दिल्ली में एंटर हुए कॉन्ट्रैक्ट के लिए. एंड दे हैड एन एक्सक्लूसिव जुरिसडिक्शन क्लॉज ऑफ दिल्ली. और सूट भी फाइल हुआ था दिल्ली में. 8 साल बाद so A filed a suit against B in Delhi. 8 साल बाद 8 years later B ने अमेंड किया प्लीडिंग को और B ने बोला कि यार ये कोर्ट के पास जुरिसडिक्शन नहीं होगा because under section 16 property is not situated in this place, so court will not have jurisdiction. Now tell me, ये तीनों क्वेश्चन का जवाब दो. Whether Delhi court has no jurisdiction, हाँ या ना? क्या दिल्ली कोर्ट के पास जुरिसडिक्शन है या नहीं? सेक्शन 16 के हिसाब से ओनली कंसिडर सेक्शन 16. अकॉर्डिंग टू सेक्शन 16 वेदर दिल्ली कोर्ट हैज जुरिसडिक्शन और नॉट. ए फाइल्ड अ सूट अगेंस्ट बी इन दिल्ली. ठीक है. प्रॉपर्टी इज इन गुरुग्राम. फाइन. देयर इज एन एक्सक्लूसिव जुरिसडिक्शन क्लॉज कि exclusive jurisdiction clause है कि suit has to be filed only in Delhi. Now whether Delhi court has jurisdiction in this case? No. Delhi court has no jurisdiction. Delhi court has no jurisdiction. Now Delhi court has no jurisdiction. So whether exclusive jurisdiction clause is void? क्या एक्सक्लूसिव जुरिसडिक्शन क्लॉज void है इस केस में? So if Delhi court has no jurisdiction, exclusive jurisdiction clause is void or not? So say Delhi court has no jurisdiction. So whether exclusive jurisdiction clause is void in this case? Yes, the answer is yes. Yes, the exclusive jurisdiction clause is void. ठीक है. Exclusive jurisdiction clause is void. Fine. Exclusive jurisdiction clause is void in this case. That is what was held in this case. ये तीन चीजें held की. Then you have section 17. If the immovable property is situated in different courts, which courts will have jurisdiction? I told you that both courts will, in such cases, both courts will have jurisdiction, and you can file the suit in any court. Then what if the jurisdiction of a court is uncertain? So whenever the jurisdiction of the court is uncertain, in such cases you will record the statement of uncertainty, and the court will proceed to entertain the matter. And if the decree is passed in such a suit, then the decree will have the same effect as if as if the property was situated within its local limits, even though the property was not situated. So wherever the jurisdiction is uncertain, so court will just record a statement, and ultimately a decree will be passed. Decree will be passed, and in the end, uh, after ultimately a decree will be passed, and in and the suit will have the same effect as if the property were situated within the local limits of its jurisdiction. Fine. Now मान लो कि कोई statement नहीं recorded है. Consider a statement is not recorded. Say if the statement is not recorded, then in that case, if you want to set aside the suit, if you want to set aside the decree, then in that case, you will have to prove, for setting aside the decree, you will have to prove that there were no reasonable grounds for uncertainty and there was consequent failure of justice. So कहने का मतलब है दो चीजें हो सकती हैं यहाँ पर. देखो दो चीजें हो सकती हैं यहाँ पर. एक सेकंड. Just give me a second. Fine. So two things can happen here. Wait a second, मैं color change कर लूँ. ठीक. So two things can happen here. पहला है कि statement is recorded. So if the statement is recorded, मान लो statement is recorded, so decree will have effect. Decree will have effect as if the court has jurisdiction. As if court has jurisdiction. जैसे कोर्ट के पास jurisdiction है वैसे ही effect हो जाएगा decree. But मान लो statement is not recorded. एक बार के लिए मान लो no statement is recorded. तो उस केस में two things that you will have to see. पहला है कि whether there are reasonable grounds for certainty. So if there are no reasonable grounds for uncertainty. So if there are no reasonable grounds for uncertainty. So if there are no reasonable grounds for uncertainty. So if there are no reasonable grounds for uncertainty, plus there is a consequent failure of justice. Plus there is a consequent failure of justice. Failure of justice. Plus there is a consequent failure of justice. ठीक है. So no reasonable grounds for uncertainty, consequent failure of justice. So these are the two things that you have to understand. ठीक, यहाँ पर clear हो? Till here you guys are clear? Guys, till here you guys are clear? So only in these two cases, if there no statement is recorded and there are no reasonable grounds for uncertainty and there is a consequent failure of justice, only in these two cases, the decree can be set aside. तो ये दोनों चीजें भी फुलफिल होनी चाहिए. Without them there is nothing that can be done. अब ये तो हो गया 16, 17 and 18. 16, 17 and 18. ठीक. अब आ जाओ 19 पे. 19 talks about one interesting scenario that suits for compensation of wrongs to a person. So when the suit is for compensation of wrong to a person, so if the wrong was done to a person and that person was within the local limits of the jurisdiction of one court, basically if the wrong is done to a person, then which all courts will have jurisdiction? So the place where cause of action has arisen, जहाँ पर cause of action arise होती है. दूसरा है where the defendant resides, carries on the business or personally works for gain. ठीक है. So where the cause of action arises, that place will have jurisdiction, and also the place where defendant resides, carries on the business or personally works for gain. So say a suit is for compensation of wrong. So if the suit is for compensation of wrong done to a person or a movable property, so wherever the the wrong is done, that place will have jurisdiction, and the person who did wrong, where it resides, that place will have jurisdiction. Where he carries on the business, that place will have jurisdiction. He personally works for gain, that place will have jurisdiction. So मान लो A hits B, A hits B, ठीक है, A मारता है B को, and he hits B in Calcutta, fine, but A is a resident of Delhi. Now tell me which all place will have jurisdiction. मैंने बताया दो जगहों पे jurisdiction होगी, जहाँ पर cause of action होगा और जहाँ defendant reside करता है और carries on the business और personally works for gain. So Delhi and Calcutta, both places will have jurisdiction. And this is what section 19 provides. This is suit for compensation for wrongs. तो इसको हम बोलते हैं tort. जो भी tort के cases हैं वो इसमें fall करेंगे, and also the cases involving movables. Movables भी इसमें ही fall करेंगे. Now this is your territorial and pecuniary jurisdiction. Till here you guys are clear? यहाँ तक clear हो? यहाँ तक clear हो guys? Till here you guys are clear? Wait. यहाँ तक clear हो guys? Everyone? Should we proceed? आगे बढ़ा जाए? ठीक है, ठीक है. Should we proceed? Then you have section 21. Section 21 provides for objections to jurisdiction. मान लो the court does not have jurisdiction, so how will you object? So section 21 subsection 1 says that, say if there is a territorial objection as to territorial jurisdiction, then in that case the objection has to be raised at the court of first instance, and it has to be raised at the earliest point opportunity. It has to be raised at the earliest opportunity, and it has to be raised at the earliest opportunity and before settlement of issues. And that objection will only be allowed in the cases when the objection is raised at the earliest point of time and there is consequent failure of justice. So जो दो चीजें आपको समझनी चाहिए कि when there is a objection as to territorial jurisdiction, it will be raised only when it is raised. It will be allowed only when it is raised at the earliest time. Secondly, there is a consequent failure of justice. There is a consequent failure of justice. And same goes in 21(2) when it is a pecuniary jurisdiction, objection as to pecuniary jurisdiction. It will be raised. It will be allowed only when it is raised at the earliest instance. And secondly, when there is a consequent failure of justice. When there is a consequent failure of justice. When there is a consequent failure of justice. Only in these two cases it will be raised, otherwise it will not be raised. Now this is what section 21 provides for. Then you have section 21 subsection 3. Now what exactly section 21 subsection 3 says? Section 21 subsection 3 talks about objection as to execution proceedings. Execution proceedings. So objection as to execution proceedings will be taken into account when it is taken at the earliest possible opportunity, and even when there is a consequent failure of justice. Only in those cases such objections will be allowed. This is what objections under 21 provide for. तो इसको हम बोलते हैं 21 के objections. Now section 99 talks about, now 21 talks about objections. अब section 99 talks about reversing or modifying the decree, and it puts an embargo. It says that कि भाई कोई डिक्री आप रिवर्स नहीं कर सकते, कोई डिक्री को मॉडिफाई नहीं कर सकते, just because there is any irregularity or error. But उस केस में भी अगर such a decree can be reversed and substantially varied only in the case when merits are affected. So अगर error, defect और irregularity merits को affect कर रही है, then the decree can be reversed. Otherwise it cannot be. So जो भी objections की हम बात कर रहे हैं section 21 में, those objections should relate to the merits of the case. If those objections do not relate to the merits of the case, then automatically decree will not be modified, or it will not be affected in any manner. ये आपका सेक्शन 99 था, और इससे रिलेटेड एक केस है किरण सिंह वर्सेस चमन पासवान जो 99 और 21 के रिलेशन के बारे में बताता है, जिसमें ये क्लियर है कि 99 जो है 99 सेटिंग असाइड के बारे में बात करता है, 21 कंडीशंस बताता है. सो 99 बताता है कि सेट असाइड तभी होगा एक केस जब मेरिट्स होंगे इफेक्ट, एंड 21 बताता है कि कंडीशंस क्या होंगी. फर्स्ट, ऑब्जेक्शन शुड बी रेज्ड एट फर्स्ट इंस्टेंस. सेकंड, द ऑब्जेक्शन शुड बी कॉन्सिक्वेंट टू द फेलियर ऑफ जस्टिस. अगर ये दोनों केसेस हैं तभी आप एक डिक्री सेट असाइड हो सकती है. ठीक, अब आते हैं रेस जुडिकाटा और रेस सब जुडिस पे. टिल हियर यू गाइस आर क्लियर? टिल हियर यू गाइस आर क्लियर? आर यू गाइस क्लियर टिल हियर? आर यू गाइस क्लियर टिल हियर? यहाँ तक क्लियर हो? ठीक है, शुड वी प्रोसीड? आगे बढ़े? चलिए. Now see what is res judicata and res sub judice. So say a matter has been heard and finally decided by the court. एक मैटर है जो ऑलरेडी कोर्ट ने सुन लिया है, उसको हर्ड कर लिया है, एंड द कोर्ट हैज ऑलरेडी डिसाइडेड. नाउ once it is decided, you cannot reopen that matter again. So in such cases res judicata will apply. So res judicata is an embargo once a final decision has been done. So once a matter has been finally decided, then you cannot raise that matter again in a subsequent proceedings. Then you have res sub judice. So res judicata is something that has been provided in section 11. On the other hand, res sub judice is something that has been provided in section 10. Now res sub judice is a stay, and res judicata is not a stay, rather it is a complete embargo. It is a bar. Fine. So if there is a matter, if a similar matter is pending in the concurrent court or the same court, then that matter can be stayed. अगर वही same matter किसी concurrent court में pending है या वही court में pending है, तो वो matter stay हो सकता है. That is what section 10 provides for. सेक्शन 11 बोलता है कि अगर यार मैटर डिसाइड हो गया है तो उसी विषय को वापस इंस्टीट्यूट नहीं कर सकते. इन दैट केस द सूट विल बी बार्ड. नाउ पहले तो रेस जुडिकाटा के आप कुछ फीचर्स देख लो. ये सेक्शन 10 के 11 के फीचर्स देख लो. तो फीचर्स यही है कि एक सेकंड. सो दीज आर द फ्यू फीचर्स दैट यू हैव टू अंडरस्टैंड. कि पहला है कि नो कोर्ट शिल ट्राई the same matter directly and substantially in issue, and this matter is between the same parties, and same matters between directly and substantially in issue between same parties and parties who are having same title, and the court should be competent to try, and the matter should be heard and finally decided. If these are the cases, then res judicata. If all these elements are there, pehla hai the matter is same, matter directly and substantially in issue is same in both the suits, and the matter is between same parties. The parties are having the same title, and the former court was a competent court, and the matter is heard and finally decided. अगर ये पांचों चीजें हैं, then in that case res judicata will apply, and the suit will be barred, and the court shall not try this suit or issue. ठीक है. तो अब ये क्यों, तो मैंने आपको ये बताया कि यार दिस इज बेसिकली बेस्ड अपॉन द कॉन्सेप्ट ऑफ जस्टिस, इक्विटी एंड गुड कंसाइंस. अगर कोई चीज एक बार डिसाइड हो गई है एंड एक बार फाइनल हो गई है, देन उसी कोर्ट और कंकरेंट कोर्ट के लिए ओपन नहीं है कि उसको वापस आप डिसाइड करो. अब इसके लिए पर्पस ये है कि देयर इज अ सर्टेनिटी ऑफ जुडिशियल डिसीजंस, देयर इज एन एंड टू लिटिगेशन. एक एंड टू लिटिगेशन है और मल्टीप्लिसिटी ऑफ प्रोसीडिंग्स है, और एक एक प्राइवेट पॉलिसी है, तो ये इंश्योर करने के लिए दिस प्रिंसिपल हैज बीन एडेड, एंड दिस इज ऑल्सो मैनिफेस्टेशन ऑफ द डॉक्ट्रिन ऑफ एस्टॉपल. सो डॉक्ट्रिन ऑफ एस्टॉपल का भी मैनिफेस्टेशन है. अब इस ये मैक्सिम्स पर मैक्सिम से डिराइव्ड है. Nemo debet les vexina pro una et ethema causa. A person shall not be vexed more than once for the same cause. Interest republicae utsit finis litim. It is in the interest of the state that it should be an end to litigation. So ये कुछ maxims पे ये based है ये concept. अब इसकी what are its elements? So elements simple ही है. तो आप elements में पहला elements है that the suit है. पहला है कि it is not only a bar to suit, it can be a bar to issue. So res judicata is also applicable to particular issue. So issue को भी apply होगा. दूसरा है कि it has to be between same parties. It has to be between same parties. Parties cannot be different, and they should be litigating under the same title. They should be litigating under same title, and the former court should be competent to try such subsequent suit. जो former court है, it should be competent to try such subsequent suit, and the matter should be heard and finally decided. And lastly, so पहला है कि matters directly and substantially in issue should be same in both the suits. It should be between same parties. Title should be same. It should be the parties should be competent to try such a suit, and the matter should be heard and finally decided. अगर ये सारी चीज़ें हैं then automatically res judicata will apply. फिर उसके बाद आता है res sub judice. Res sub judice में भी ये सारी चीज़ें होनी चाहिए except heard and finally decided. One thing that you have to understand about res sub judice that the suit is pending. So res sub judice में क्या हो रहा है कि there are two suits that are pending. So one suit with the same matters directly and substantially in issue is pending before the another suit. So same matter directly and substantially in issue is pending before before the same court or concurrent court. So this second suit will in such cases will be stayed. ये जो second suit है उसको हम stay कर देंगे and we will not proceed with such a suit. ठीक है, this is the overview of the section. Now come to section 27. Now section 27, अब ये तो section 27 में बाद में आते हैं. Till here you guys are clear? यहाँ तक clear हो? Are you guys clear till here? यहाँ तक clear हो? Till here you guys are clear? ठीक है. Now come to one important aspect that we have to discuss. एक important aspect जो हमें discuss करना है उस पर आते हैं. Just give me एक सेकंड. Wait a second. Visible? एक सेकंड, दिख क्यों नहीं रहा? Visible है? Visible right? Visible है ना? Guys visible? Okay. ठीक है, अब आगे आ जाओ. अब लेट्स अंडरस्टैंड वन इम्पोर्टेंट एस्पेक्ट. एक second. अब देखो, we'll understand one important aspect, that is something known as transfer. Now, what exactly is transfer of suits, and in what cases such a transfer is permissible? ये एक बार समझ लेते हैं, and then we'll proceed further. So देखो which court has power to transfer, पहले तो ये समझो. Which court has section 22? See, transfer has been provided. The concept of transfer has been provided in section 22 to 25. ठीक है, 22 to 25 में concept of transfer provided है. Now, which court has the transfer where you can which court has the power to transfer? So पहले तो where a suit may be instituted in any of the two courts. मान लो किसी दो कोर्ट में सूट इंस्टीट्यूट हो सकता है, पर वो एक कोर्ट में इंस्टीट्यूट है. So any defendant after giving notice to the other party can opt for transfer. ठीक है, he can opt for transfer. बट अब ट्रांसफर कैसे ऑप्ट करेंगे? और एक सेकंड, just give me a second. हाँ, no, it's perfect. ठीक है. Now where will you file an application for transfer? Where exactly do we file an application for transfer? ठीक है, आप एप्लीकेशन ट्रांसफर की कहाँ पर फाइल करोगे, and how exactly you will file an application for transfer? That we have to understand. So now let's understand the application for एक सेकंड. ठीक है, where exactly an application for transfer is supposed to be filed? So where several courts are having jurisdiction and they are subordinate to the same appellant court. मान लो बहुत सारे courts हैं, they are having jurisdiction and they are subordinate to the same appellant court. So that appellant court will have jurisdiction. That appellant court will have jurisdiction, and then that appellant court uh, you'll have to you'll have to make you'll have to put a transfer application in that appellant court. So if several courts are having application, will have jurisdiction. अगर एक court मतलब और and court number B, ये दोनों भी subordinate हैं appellant court. Now if you want to transfer the case from A court to B, so you will have to file an application before this appellant court only. ठीक है, this is what section 23 provides, कि अगर दो कोर्ट सबऑर्डिनेट हैं एक appellant कोर्ट में, तो उस appellant कोर्ट के पास आपको एप्लीकेशन फाइल करनी पड़ेगी. बट मान लो if two courts are subordinate to different appellant courts, if two courts are subordinate to different appellants court, then in that case the application will be filed to high court. उस केस में आप हाई कोर्ट के पास एप्लीकेशन फाइल करोगे. बट अगर आपको एक हाई कोर्ट से दूसरे हाई कोर्ट में केस ट्रांसफर करना है, और अ कोर्ट हु इज सबऑर्डिनेट टू वन हाई कोर्ट टू अनदर हाई कोर्ट, तो उस केस में कहाँ एप्लीकेशन फाइल करोगे? अब यहाँ तो लिखा है कि द एप्लीकेशन विल बी फाइल्ड बिफोर द कोर्ट where the application was first filed. तो वही कोर्ट डिसाइड करेगा, that court can actually transfer. But this is wrong, and it has to be filed before which court? It has to be filed before which court? बताइए, एक हाई कोर्ट से दूसरे हाई कोर्ट में ट्रांसफर करने के लिए कौन से कोर्ट में फाइल करोगे? सुप्रीम कोर्ट. And this is something which was held in दुर्गेश शर्मा versus जयश्री. दुर्गेश शर्मा वर्सेस जयश्री में दिस इज समथिंग व्हिच वाज हेड. ठीक है, अब उसके बाद आता है जनरल पावर टू ट्रांसफर एंड विड्रॉल. सो अगर एप्लीकेशन ऑन द एप्लीकेशन ऑफ एनी ऑफ द पार्टीज, on application of any of the parties and after notice to the parties and after hearing such of them as desired to be heard or of its own motion without such notice, the high court or the district court may at any time. So this is the power of high court or district court to transfer at any stage, to transfer at any suit, appeal or other proceedings. जो power supreme court का है, that is something which has been provided in section 25. Section 25 में you have the power of the supreme court to transfer to transfer the proceedings from one high court to another, or a court subordinate to one high court to another. But in this case, one thing that you have to understand, that it has to be expedient for the ends of justice. The transfer is permissible when only it is expedient for the ends of justice. So where it is not expedient for the ends of justice, then the transfer is not maintainable. So the transfer can take place only when it is expedient for the ends of justice. So जहाँ पर it is expedient only for the ends of justice, then only the transfer will kick in. Otherwise, the transfer will not kick in. Now, this is what section 25 provides for. With this, we are done till sections. यहाँ तक 26 तक तो हम आ गए हैं. अब समन्स पे आते हैं. क्लियर हुआ था? क्लियर? यहाँ तक क्लियर हो? क्लियर हुआ था? क्लियर? क्लियर हुआ था? क्लियर? यहाँ तक क्लियर हो? ठीक है. अब समन से पहले मुझे एक बार सेक्शन 13 कवर करना है. सेक्शन 13 में फटाफट कवर कर लूँ. अब सी सेक्शन 13 में ज़्यादा कुछ नहीं है. सेक्शन 13 इज टॉकिंग अबाउट फॉरेन जजमेंट्स. नाउ व्हाट एग्जैक्टली डू वी मीन बाय फॉरेन जजमेंट्स? ये समझो कि सी अब देयर if there is a foreign judgment, so that foreign judgment in India, that will be conclusive. मतलब see, res judicata cannot apply on foreign judgments. A foreign judgment can only be conclusive in India. So conclusive means this is the evidentiary value of foreign judgment. When I say conclusive, I mean to say that it is not rebuttable on a particular matter. You cannot rebut foreign judgment on these specific matters. So on the matters which are directly adjudicated upon between the same parties, or between the parties whom under they are claiming, or under the same title. So if you are directly adjudicating, you are conclusive. If you are directly adjudicating, or if you are adjudicating between the same parties, ठीक है. So if you are directly adjudicating, or if you are if you are conclusive, so sorry, if the matter is directly adjudicated, or if the matter is conclusive, in such cases, and if the matter is between the same parties, in such cases the foreign judgment will be conclusive. So when it will be conclusive? So it will be conclusive if these conditions are fulfilled. So if the foreign judgment is not pronounced by a competent jurisdiction, if the foreign judgment has not been given on merits, if the foreign judgment has been pronounced by competent jurisdiction, if the foreign judgment is given on merits, or if the foreign judgment is not based on an incorrect view, if the foreign judgment was obtained or is not opposed of any natural justice, if the foreign judgment was not obtained by fraud. So if the following things are not, basically if the foreign judgment does not fall under the clauses A to F, then the foreign judgment is basically conclusive. You can say that the foreign judgment is conclusive. Now clauses A to F are C, M, I, N, F, B. तो पहला है कि the foreign judgment is not pronounced by competent jurisdiction. दूसरा है foreign judgment is not given on merits. Foreign judgment is to be found on an incorrect view of international law, or refusal to recognize law of India, or foreign judgment is opposed to principles of natural justice, or foreign judgment is obtained by fraud, or there is a breach of any Indian law. So CM, Chief Minister in Facebook. तो ये है foreign judgment. Basically, these are the embargoes on foreign judgments. अगर foreign judgments if the foreign judgments fall within this criteria, then basically foreign judgment is not conclusive on that particular matter. Then you have section 14. Section 14 talks about competent jurisdiction, whether the foreign court has competent jurisdiction. So the court says, section 14 says that in such cases we will presume if the document has been prepared, if the proper document has been prepared. Say if the document has been if the proper document has been produced, if there is a proper document that has been produced, in such cases we will presume uh, that there is a want. If there is a proper document that has been produced, in such cases we will presume that the foreign court has competent jurisdiction. So upon production of proper document, upon production of proper document, upon production of proper document, it has to be proved that court has jurisdiction. Whose case में you can prove that the court has jurisdiction. Foreign court has competent jurisdiction, but document has to be proper. Fine. अब ये हो गया section 14. This is what section 14 talks about. अब एक और चीज है फॉरेन जजमेंट से एसोसिएटेड, दैट इज एग्जीक्यूशन ऑफ फॉरेन जजमेंट. नाउ दैट इज समथिंग व्हिच हैज बीन प्रोवाइडेड इन 44A. अब इससे रिलेटेड हमें एक इंटरेस्टिंग डिस्कशन करना होगा कि देखो व्हेन द केस रिलेट्स टू एग्जीक्यूशन ऑफ फॉरेन जजमेंट. अब जब भी केस एग्जीक्यूशन ऑफ फॉरेन जजमेंट की बात आ रहे हैं तो फॉरेन जजमेंट डायरेक्टली एग्जीक्यूट नहीं हो सकता. आपको यहाँ पर इंडिया में सूट फाइल करना होगा. सूट फाइल करने के बाद आपको उस सूट को कंक्लूसिव डिक्लेयर कराना होगा. सूट फाइल करने के बाद फॉरेन जजमेंट आप उस सूट में प्रेजेंट करोगे एंड फिर फॉरेन जजमेंट कंक्लूसिव होगी एंड फिर इंडियन कोर्ट एक डिक्री पास करेगा और फिर ही आप एग्जीक्यूट कर सकते हो अकॉर्डिंग नॉर्मली. बट देयर इज वन स्पेसिफिक केस इन विच अ फॉरेन जजमेंट कैन बी एग्जीक्यूटेड, and that is something which has been provided in section 44A. ये फॉरेन जजमेंट जो फॉरेन कंट्री में पास हुई है, इंडिया में बिना सूट फाइल किए डायरेक्टली यू आर एग्जीक्यूटिंग इट, एंड दिस इज डायरेक्ट एग्जीक्यूशन ऑफ फॉरेन जजमेंट. बट दिस विल हैपन only when the decree that you obtained in foreign country is a money decree. Only if it is a money decree. जब वो फॉरेन जजमेंट में आपने फॉरेन कंट्री में जो डिग्री आपने ऑब्टेन की वो मनी डिग्री है, तभी ये अप्लाई होगा, ऐसे नहीं अप्लाई होगा. सो दिस विल अप्लाई ओनली इन द केसेस वेयर इन द डिग्री दैट यू हैव ऑब्टेन्ड इन द फॉरेन कंट्री इज अ मनी डिग्री. एंड सेकेंड थिंग दैट यू हैव टू अंडरस्टैंड दैट दिस विल बी एप्लीकेबल. आई मीन the judgment passed in foreign country can be executed in India only when a certified copy of a decree of a superior court of a reciprocating authority has been filed in the district court. So basically certified copy of decree is filed. पहला certified copy of decree चाहिए, certified copy of decree of superior court, and दूसरा है this superior court is from reciprocating authority, and this certified copy has to be filed in district court. Then only there can be direct execution, and this direct execution can take place only of the money decree. So not of any other decree, only of money decree this direct execution can take place. मनी डिग्री का ही एग्जीक्यूशन हो सकता है और किसी का नहीं हो सकता डायरेक्ट एग्जीक्यूशन. ठीक है, क्लियर हुआ? क्लियर? यहाँ तक क्लियर हो? गाइस क्लियर हो गया था? क्लियर गाइस? क्लियर हो? क्लियर. ओके, अब आ जाते हैं समन्स पे. अब समन्स में ज्यादा कुछ हमें समझना नहीं है, आप बस इतना समझ लीजिए कि सूट हैज बीन ड्यूली इंस्टीट्यूटेड, अ समन हैज टू बी इशूड. ऑब्वियसली अगर जब भी सूट फाइल होता है समन होगा इशूड, एंड समन will be executed, will be instituted not beyond 30 days from the date of institution. So it has to be instituted not beyond 30 days. तो नॉट बियॉन्ड 30 days समन आप सर्व करोगे 30 दिन के बाद नहीं, ठीक है। तो ये दूसरा है दूसरे स्टेट में समन सेंड करने का क्या प्रोसीजर है। सो इट विल बी द प्रिस्क्राइब बाय द रूल्स इन फोर्स इन दैट स्टेट। एंड देन यू हैव फॉरेन समन्स का क्या प्रोसीजर है। एंड देन पावर टू ऑर्डर डिस्कवरी। अब सेक्शन 30 इंपॉर्टेंट है बिकॉज 30 में द कोर्ट हैज अदर पावर्स। So court can order the following. Court has following powers. So court क्या है? Court can ask the parties. So on its own motion or on application of the parties, court can ask for court can ask the parties to deliver an answer interrogatory. Court can ask for admission of documents and facts. Court can go for discovery, inspection, production, impounding, return of documents or other material objects producible. All these aspects are provided in Order 10 to 13. ये सारी चीजें Order 10 to 13 में कोर्ट कर सकता है। फिर कोर्ट समन्स इशू कर सकता है उस व्यक्ति का whose attendance is required to give evidence, जिसकी अटेंडेंस जरूरी है एविडेंस देने को और डॉक्यूमेंट प्रोड्यूस करने को। कोर्ट बोल सकता है कि एक पर्टिकुलर फैक्ट एफिडेविट द्वारा प्रूव किया जाए। दैट कैन आल्सो हैपन। देन यू हैव समन्स ऑफ विटनेस। कोर्ट कैन समन टू विटनेसेस। सो 27, 28, 29 will apply to summons to give evidence or to produce documents or material facts. So summons to witnesses can also apply. ठीक है। Summons to witnesses can also apply. Court can also, जरूरी नहीं है कि सिर्फ पार्टीज को समन करे। कोर्ट कैन समन ऑल्सो। अगर मान लो जो 30 में कोर्ट ऑर्डर करता है, मान लो कोर्ट ने इंटरोगेटरी को जवाब देने का ऑर्डर कर दिया, कोर्ट ने एक डॉक्यूमेंट को एडमिट करने का ऑर्डर कर दिया, कोर्ट ने डिस्कवरी का ऑर्डर कर दिया, कोर्ट ने इंस्पेक्शन का ऑर्डर कर दिया, कोर्ट ने प्रोडक्शन का ऑर्डर कर दिया, इंपाउंडिंग का ऑर्डर कर दिया, एंड दैट इज नॉट ओबेड, दैट इज नॉट complied with. In that case, what will happen? In that case, court can pass following orders. पहला है, court can issue a warrant for his arrest. Court can attach and sell his property, and court can impose a fine. ये बहुत important है, and that fine will not exceed 5,000 rupees. And court can order him to furnish securities for his appearance in default and commit him in civil prison. Court can order him to furnish securities and commit him in civil prison. Now, this is what section 32 talks about. Okay, clear? Clear? ज़्यादा clear हो? Clear? Guys, ज़्यादा clear हो? Yes. ठीक। So this is with regards to summons. अब आगे आते हैं। Now let's understand judgment. तो ये तो easy है। Let's understand something known as judgment. What exactly is judgment? एक बार ये judgment को समझते हैं। देखो, judgment को समझने से पहले let's understand what exactly is a decree. So see, two things that you have to understand. So decree is something that has been defined in section 2.2. तो आपका जो decree है, that is something which has been defined in section 2.2, and judgment is something which has been defined in 2.9. So ये आपका decree है, decree has been defined in 2.2, judgment is defined in 2.9. Now what exactly decree is? See, decree is basically the conclusive determination of rights and liabilities of a party, of the parties in a suit. So it is a formal adjudication of a dispute, and on formal adjudication of a dispute, it is conclusive determination of rights and liabilities of the party. Judgment is the grounds on which a decree is based. तो जिस ग्राउंड्स पे डिक्री बेस्ड है वो जजमेंट है. फाइन. तो इसके लिए द कोर्ट इन ऑल केसेस अ डिक्री शैल फॉलो अ जजमेंट. सो एक जजमेंट होगा, जजमेंट के बाद आपका डिक्री शैल फॉलो. सो जजमेंट के बाद डिक्री शैल फॉलो. ठीक है. अब एक बार देख लो कि 2 और 2 9 क्या बोलते हैं. एक सेकेंड. ठीक है. अब 2 बोलता है डिक्री मीन्स अ फॉर्मल एक्सप्रेशन ऑफ एजुडिकेशन. तो 2 में डिक्री इज अ फॉर्मल एक्सप्रेशन ऑफ एजुडिकेशन. ठीक है. And it conclusively determines the rights of the parties with regards to all or any matters in controversies. Now, decree can be preliminary and it can be final also. And one thing that you have to understand that decree includes rejection of plaint and determination of a question within 124. So, decree includes Order 7, Rule 11, and along with Order 7, Rule 11, decree also includes Section 124, Section 144, that is restitution. ठीक है. But decree does not include DID, that is dismissal for default. Dismissal in default को नहीं include करता. And decree does not include an adjudication from which an appeal lies from an order. So जहाँ पर appeal, if an appeal lies from an order, that does not include in decree. So if the appeal lies from an order, that will not be in decree. वो decree में नहीं fall करेगा. So decree में DID, appeal from an order, appeal from an order is not a decree. Dismissal and default is not a decree. Rejection of plaint is a decree. Restitution is a decree. Order of restitution is a decree. अब judgment क्या है? आपका judgment है 2-9. Judgment is the statement grounds of decree. जिस ground पर decree based है वो है judgment. जिस ग्राउंड पर डिक्री आपकी बेस्ड है दैट इज जजमेंट. ठीक है. तो ऑर्डर क्या है? अब ऑर्डर इज समथिंग विच हैज बीन प्रोवाइडेड इन 214. 214 में ऑर्डर का मतलब है इट इज द फॉर्मल एक्सप्रेशन ऑफ एनी डिसीजन ऑफ सिविल कोर्ट विच इज नॉट अ डिक्री. सो इट इज फॉर्मल एक्सप्रेशन ऑफ एनी डिसीजन ऑफ सिविल कोर्ट. ये फॉर्मल एक्सप्रेशन है सिविल कोर्ट के डिसीजन का जो डिक्री नहीं है. ठीक है. सो इट इज अ फॉर्मल एक्सप्रेशन विच इज नॉट अ डिक्री. एक फॉर्मल एक्सप्रेशन है जो डिक्री नहीं है. तो डिक्री और ऑर्डर में फर्क क्या है? तो डिक्री और ऑर्डर में फर्क क्या है? डिक्री कंक्लूसिवली डिटरमाइन करता है राइट्स एंड लायबिलिटीज. जरूरी नहीं है ऑर्डर कंक्लूसिवली डिटरमाइन करे. डिक्री पुट्स एन एंड टू द डिस्प्यूट. डिक्री खत्म करता है डिस्प्यूट को. जरूरी नहीं है कि ऑर्डर खत्म करे. सो ऑर्डर एक फॉर्मल एक्सप्रेशन है बट जरूरी नहीं है कि ऑर्डर हर केस में कंक्लूसिवली डिटरमाइन करे राइट्स एंड लायबिलिटीज. जरूरी नहीं है कि हर केस में it puts an end to the dispute. This is the major difference between order and decree. ठीक है. Till here you guys are clear? यहाँ तक clear हो? यहाँ तक clear हो guys? Till here you guys are clear? Clear? ठीक है. एक सेकेंड. ठीक. ठीक है. ठीक है. ठीक है. Let's call it a day. We'll continue with this tomorrow. We'll continue with the rapid revision tomorrow. यहाँ तक ठीक है? यहाँ तक clear हो? Are there any doubts guys? Do you guys have any doubts? Do you guys have any doubts? Any doubts so far? Clear. ठीक है, ठीक है, ठीक है गाइस, सी यू गाइस टुमारो। ठीक है, रिवाइज करो एक और बार, कल फिर से करते हैं। ठीक है।